అందరికీ శుభోదయం. గుడ్ మార్నింగ్ to all of you. Welcome to Legal Matters by Sai Babu Sunkar. This video is relating to the subject: can anticipatory bail be granted in SC/ST Act cases? The simple answer is no, but Supreme Court clarified that if there is no prima facie case established, then you can give anticipatory bail. Three judges bench of the Honorable Supreme Court of India, Chief Justice of India, Justice B.R. Gawai, Vinod Chandran and Anjaria. Right. So, in the case of Kiran versus Rajkumar, jivraj jain and others on 1/9/2025, they granted anticipatory bail to the accused person in this particular case. The case is 255/2024, registered under different sections of the Bharatiya Nyaya Samhita like 118, 333, 115, 33, 324 and 354 of Paranda PS in Maharashtra state. The case was registered on 25/11/2024. If you go to the brief facts of the case, it was alleged that soon after the results of the assembly elections in 2024, in this village, the accused persons came upon the house of the complainant. She is a lady, while she and her family members were present in the house. Then there actually, at first the servant came, then the sarpanch came, and they asked her as to how much guts you have got to cast your vote to the opposite party. Then she said, to exercise the vote is my selection. You can't compel me to do like that. Aggrieved by this, immediately these people, the so-called Rajkumar, Jain and others, Jain is the sarpanch of the village, and others, they assaulted her, abused her with caste names, because for not voting to a particular candidate which was mandated by them to her. Right. So, after the incident, the other people instigated her. Anyway, she went to the police station and she gave a report. It was registered. Yes, the regular process has been followed. No doubt in it. Now, the accused, of course, you all know that sarpanch means influential person. He approached the local court, that is local sessions court, which denied bail, anticipated bail to him. Then he approached Bombay High Court. Bombay High Court, basing on the statements of the witnesses, after perusing the CD, they held that there are certain discrepancies or variations in the statements of the witnesses. So therefore, in the month of April 2005, Bombay High Court granted anticipatory bail to the accused. Now, agreed by this, once again, the petitioner, that is Kiran, they approached the Honorable Supreme Court of India. I think you have understood the brief facts of the case. Simple, caste-based assault, particularly since she did not cast her vote to the particular candidate. That what more is necessary? Anyway, now Supreme Court set aside the anticipatory bail orders of the Bombay High Court, stating that it is a manifest error. You know, Section SC/ST Prevention of Atrocities Act is a special act intended to protect the so-called community people, SC and ST people, and against to the so-called victimization. But granting bail, and you have to go through section 18, very very important. Section 18 says all the offences may be punishable for 6 months. All the offences in this act, they are non-bailable. Very specifically, they have noted. So therefore, the High Court, what High Court has done is a clear illegality and also jurisdictional error by the High Court. So order could not be sustained in the eye of law. Of course, if on the bare reading of the FIR, if the contents of the SCST are not made out, yes, in such a case, please remember, in this case of exception, definitely. That means when the FIR prima facie case does not show any SCST offense, definitely the so-called anticipatory bail can be given. Because there is a need for the victim protection. Of course, at the same time, the accuser also should be protected from the frivolous or the false FIRs. So, Supreme Court has striken a balance between both these two things and said that if there is no prima facie case, definitely anticipatory bail can be given. If not, anticipatory bail cannot be granted. So, if you understand this much, it is sufficient. For that, it's not that easy. Please go through the case law, and if you find time, please read the so-called SCST Prevention of Atrocities Act 1989. Okay, I'm stopping here. And one more thing I want to tell you before forgetting. In the case of Rajkumar versus State of Bihar 2014, the Supreme Court said offences below 7 years punishment, the police can give 41-year notice. Taking advantage of that, so many people got bail and they not arrested in this particular act also, which is not correct in my view. But anyway, Supreme Court said, yes, give 41-year notice. They have not categorized that in SCST cases you should not give. Okay, I am stopping here. Thank you.